Good evening, hello and welcome to Plain Speak. I'm Anusha Soni. The Varanasi District Court has rejected the plea of the Hindu side for carbon dating of the disputed structure found within the Wuzu Khana of the Gyanvapi complex. A plain reading of that order, a two-page order, would tell you that the court has rejected the petition on the ground that the Supreme Court had ordered the sealing of the particular area, and the Supreme Court apprehended that the safety and the security of the structure needs to be protected and should not be jeopardized. The order, interestingly, is not passed on the merits of the application but on the questions of procedure. The fact that Wuzu Khana is sealed makes it obvious that one day or the other, the truth about the disputed structure has to be ascertained legally. Is this a setback to the Hindu side? Which way does it take the dispute, and what will be the next turn in this very sensitive legal tussle going on? Our top focus tonight.
Welcome the judgment of the civil court regarding the carbon dating issue of the Shivling. When the whole of the area is sealed on the order of the Supreme Court, how can any activity or carbon dating can be done?
इस ऑर्डर के अगेंस्ट हम सुप्रीम कोर्ट जाएंगे, इस ऑर्डर को हम सुप्रीम कोर्ट में चुनौती देंगे।
Well, there are two ways to look at what has happened at the Varanasi District Court. One is the immediate setback for the Hindu side because they wanted a scientific process / carbon dating of the disputed structure, which the Hindu side says is a river Shivling and the Muslim side argues is a mere fountain. The Supreme Court has placed prohibitory orders. The entire area is sealed. Nobody can go there. But why is it arguably a setback for the Hindu side? Let's take you through some key pointers, some key details which are emerging as far as this entire debate is concerned. Scientific probe will be the violation of the Supreme Court order on sealing. Whether it's a Shivling or not, only a scientific investigation will tell us so far. These are claims. Carbon dating can possibly damage the structure which is claimed as a Shivling. That's what the court has said. The court has further said that the sentiments of the people might be heard by this entire procedure. The fear is that that entire structure, which is the Shivling, which is called Shivling by the Hindu side, may be damaged in this process which may be taking place. Chances of a legal resolution of the dispute might be impacted. The apprehension of the district court is that they don't want to violate the orders of the Supreme Court, which will be for any district court in the country. Now, let's take you through the arguments on both the sides. How does the order of today pan out for both the sides? What are their options? What is likely to happen? For the Hindu side and the Muslim side, what does this order mean? They've said that they're going to appeal against this order, a very likely scenario for any party who is seen to be losing. They see as a big victory in this battle, at least in the ongoing legal dispute. First, they lost the first order that had come in. This is a good thumbs up for them. It will also strengthen the Muslim side's plea in the case and other remedies which have been sought by the Hindu side. They had sought a nod for other remedies like ASI survey. So the Hindu side had said that, listen, if you can't give us carbon dating, we are open for other scientific methods as well. As they seek that nod for the ASI survey, and appeal to a higher court is going to be very, very critical. Let's move forward and look at other details as well. They could ask the court for scientific probe other than carbon dating so that it doesn't damage the structure, the apprehension which has been expressed by the district court. The Muslim side says that they can stand by the claim that object being called Shivling is a mere fountain. They have said that there is no need for any kind of a survey. The Muslim side further argues that they can cite the Varanasi court order as a precedent to oppose any other kind of survey, the fact that the lower court has taken a view which prima facie is in their favor. The Hindu side can say that demand to survey the area outside the Shivling. More importantly, many people would argue that the short two-page order is merely on the procedure of it. It's not on the merits of the application. We'll talk more about that. But where does it lead the dispute? What happens from here on? What are the implications? Wuzu Khana remains sealed. No scientific investigation done so far. It cannot remain sealed forever. One day or the other, you'll have to ascertain, or the Supreme Court will have to take back its orders. Very unlikely to happen. Court to decide on how to move ahead with the sealed structure. The Supreme Court, of course, had passed those orders. Shivling versus fountain, that's what has been said by Hindu versus the Muslim side. That debate needs to be settled. It cannot be left in thin air because sentiments are involved on both the sides. Varanasi court will have to decide on the right to worship at Ma Shringar Gauri, the initial application or the plea which is pending before the district court. That's the question we asked tonight. Hindu side says they are going to appeal against this order. Carbon dating, of course, has been denied. Is this the end of the road for Hindu side or merely a short setback that they can perhaps deal with as and when they approach the higher court? Well, joining us tonight is our leading newsmaker, Mr. Hari Shankar Jain, who is the leading lawyer for the Hindu side and a petitioner in this case, is joining us on the broadcast this evening. Sir, thank you so much for talking to us. I'd like to know from you what your views are, especially after the plea of carbon dating has been rejected. What is it that you see? Do you see this as a setback, or you are hopeful that at a higher court you may find a resolution? Mr. Jain.
Unnecessary. It is being said that it is a setback for Hindus. No setback, no question of any setback. The plaintiff and their counsel, they are ready with the case, with full material, and we have all the evidences. Number one. Number two, it is fountain or Shivlingam. One day or the other, it has to be examined by scientific evidence. Scientific evidence has to take place. For the time being, the Honorable Court was of the view that in view of the judgment order passed by the Honorable Supreme Court on 17th May, that may be violated if carbon dating or scientific investigation or GPR survey is ordered. That is why. But that is misnomer, because in subsequent order dated 20th May, the Honorable Supreme Court has clearly said that the Court of District Judge will be fully empowered to decide all the applications and ancillary applications. Next, kindly consider why Muslim party, they are opposing this scientific investigation. Why? They are saying that it is fountain, Pawara, then should face, they should prove it. Why they are avoiding? Avoidance means they know that it is Shivlingam and it will be proved after investigation by science. Therefore, they are avoiding and opposing.
Well, sir, you're right in pointing that out. I've read the order, and there are very limited grounds. And the only ground which is cited by the court is simple, that you've said that, the Supreme Court order is in place and we don't want to disturb it. And that's why they're denying the, the entire request for any kind of carbon dating. They have not gone into the merits of the case. With that being the position at the district court, what is your legal strategy forward? Are you going to the High Court? And also, there's this entire theory that there's already a 1991 dispute which is pending at the High Court. And you're creating multiple causes of action for a similar dispute. Respond to that, sir.
I've just told you that court has rejected mainly on the ground that it may violate the order passed by Honorable Supreme Court on 17th May. But court has forgotten to peruse the order dated 20th May, in which Supreme Court has specifically mentioned that its decisions will be entitled or empowered to decide all the applications, including ancillary applications.
Okay.
The court has not rejected on the ground that it is on merits, but simply on the presumption. And even...
No, I think that's a very important point you're mentioning, that after the district court, you need not go to the High Court. Will you directly go to the Supreme Court for the clarification? And what kind of clarification, sir?
No, I may tell you. No.
Yeah.
They are absolutely that conception is misconceived. That GPR survey is limited to the other part of the building. Here, the prayer was regarding Shivlingam, which has been discovered only on 16th May, not before that date. And both things are different. And I propose to, for the time being, today what I have made up my mind, that I have to go to Supreme Court. Because the Honorable District Judge has passed an order in the wake of order dated 17th May, without caring for the order dated 20th May. So it requires a clarification. Requires clarification by the Supreme Court. So it will not be fruitful to go to the High Court, but I will go to Supreme Court. So far I propose today. Tomorrow again I will read and prepare. And I think that is Supreme Court will clarify or should clarify that order dated 17th May is no bar and should not come in the way of the district judge in disposing the application.
So, yeah, so that's a very important clarification that you will seek directly from the Supreme Court. There is no need to go to the High Court. Let's come to the methods that the Hindu side has been talking about. The carbon dating has been rejected. The apprehension that the district court has expressed is that it might damage the structure. What, according to the Hindu side, is the correct scientific method to ascertain whether it's the revered Shivling or not?
Yes. For clarification, yes. Clarification that the district judge is empowered to decide the application of scientific investigation on merits without being swayed away, without being influenced by the order dated 17th May.
Okay.
And both the order 17th May and 20th May both have to be read together. Okay. And court is empowered to decide all the applications. Number two, the investigation, scientific investigation has to take place today or tomorrow. One party is saying in a fountain, other party is...
No, and you know, the fact that, you know, it has been contested that whether it's a fountain or it's a mere Shivling needs to be settled, as you rightly said, sir, by some kind of scientific method. So that's what I want to understand from you, that what exactly according to you is the correct scientific method, because the fear is that the carbon dating may affect what the Hindu side claims is a revered Shivling.
देखिए, I am not a scientist. I am not a scientist. The Supreme Court in Ajodhya case has ruled that ASI has sufficient means to determine the age of anything. And I have prayed not for carbon dating as such. I have prayed that the scientific investigation may take place and carbon dating or otherwise the age and nature of the idol that has to be determined. That is my simple prayer. The carbon dating, the fear that due to carbon dating there may be damage to Shivlingam or that article which was found, that is misplaced. I have not said so. And I clarified before the court, I made a statement before the court that without touching, without causing any damage of any kind, the Shivlingam, the investigation may take place. And I may tell you that on one new channel, director of archaeology has especially stated that we have sufficient means to determine the age and nature of any place of worship or any article which has been found.
Okay. No.
There is no dispute.
Yeah. Sir, I take your point, but I want also you to also respond to this larger criticism which is coming in. That originally this suit was about the right to worship of Ma Shringari Gauri. And by going to the disputed structure within, by saying that it's a Shivling, you're trying to widen the ambit of the dispute, because eventually if Hindu side is proven wrong, it will open a wider argument. It will open an argument for the proprietary rights of a deity, which according to the Hindu side is a Swayambhu Shivling.
Yes, I may clarify that this argument is misplaced because in the prayer, the clear prayer that visible and invisible deities, we should be given right to worship the visible and invisible deity. On the date of filing the suit, the Shivlingam was invisible. On 16th May, it became visible as soon as the water was shortened. As soon as, then we came to know that he is the Shivlingam. So that is part of the suit property, and that is very well included in the relief lodge, and it is not out of way. It is very clear from the affirmation plate in the plaint. Again I am saying that we should be given right to worship the visible and invisible deity. At the time of filing the suit, it was invisible. Yes. Can you appreciate it?
I understand that, sir. If this is a Shivling as you're claiming it to be, and the rights that you're seeking are the rights of Shabiat, the deity will also have a right to property, and it will also have a right to sue through, the person holding the Shabiat or the person who is the first friend. Is that the legal strategy that you're going to adopt? Because that will make this dispute very, very broader in nature compared to what it is right now.
Yes, naturally. That is what I am saying. That once it is held after some investigation by scientific method or otherwise, which is permissible under law, it is Shivlingam, then we will get right to worship. And will the great victory for those devotees who are waiting to worship Shivlingam for the last 353 years, right from 1670, when the temple was demolished. And I will tell you one thing more.
Yes.
They are confusing that ASI report has been asked by the second ASI report. The matter is pending before the High Court. That ASI report is confined or connected to the other part of the building. Here Shivlingam has been discovered on 16th May. Both things are altogether different.
Okay.
There can be no difficulty. It is not connected with that GPR survey.
All right.
And I am going to Supreme Court
yes.
for a clarification.
All right, sir. Harishankar Jain ji, बहुत shukriya. Thank you so much for your time. And I hope to see you at the Supreme Court as and when that matter is taken up there. Thank you so much for giving us your time. I'm opening up this question for our legal experts as well who are joining us on the broadcast and our political experts who will take this debate forward. We have with us on the broadcast Mr. Firoz Bakht Ahmed, who's the former Chancellor at the Maulana Azad National Urdu University. Mr. Ratan Sharda, who's a researcher also and a political analyst, is joining us on the broadcast. Ms. Ranjana Agnihotri, who is one of the petitioners in this case. Shahid Ali, who's an advocate and also a leader at the United Muslims Front. Tanish Qureshi, who's a political analyst, is also joining us on the broadcast. Ratan Sharda ji, I'll begin with you. We just heard Mr. Jain, one of the leading lawyers from the Hindu side, and he says that one day or the other you'll have to settle this. You've not allowed carbon dating at this point in time because of the Supreme Court orders. We will seek a clarification and this answer needs to be sought if it's a shivling or a fountain.
Yeah, I totally agree with Mr. Jain. First of all, from where did all this start? It started because way back 1992, the worship of God was stopped by the Mulayam Singh Laheta government, and that led to a discontinuity of a practice which was there for hundreds of years. So women went to court. From there on, the issue went on ahead because Muslims refused to compromise, refused to give the right to the Hindus which were already existing till 1992. Now that having gone there was a call by court to have a survey. We found that the walls of the Gyanvapi so-called mosque already had a lot of Hindu signs, which was expected because this is on the record of the Arabic and Mughal historians who tell us how it was destroyed and how it was converted to mosque. Having done that, now the issue came up of the Shivling. Now Shivling was declared that it was a fountain. Now I think scientific evidence that we talk about, forget the carbon dating and all. What court needed to do, ask the Muslims who claimed it to be a fawara to please run the fawara. They said we can run it. So the simple thing was to use it because that will not damage the structure anyway. And court on the 20th May did give permission to the local court to take action what was required. So scientific evidence does not require carbon dating. There are a lot of other methods which court has to ask ASI. They didn't ask that. So if the people who claim that it was a fawara led to mayhem, sarkan se juda and all those debates and all those killings in the name of belief, faith, then what happened to Hindu faith? They went to court again. And now having said that scientific evidence is possible, my simple call to my Muslim brothers is please show the fountain running, or the simple way for the court was to have a examination even by radiation to show whether the pieces stuck on that particular structure were actually along with the structure from the beginning or they were attached recently.
Okay.
That was not very difficult.
Okay.
Whether the hole in the Shivling or so-called fawara went through the base, whether there is any connection, hydraulic connection for the fountain, that can be found without any reason for any kind of digging, any kind of
Through a very simple analysis, it can be found that whether it's a fawara or it's a shivling or some kind of structure. Shahid Ali, answer to that point. I mean, procedural legalities aside, what the Varanasi district court has said, and Mr. Jain also said that he's going to challenge that at the district court. One of the questions which is being asked in the public discourse is that if it's a fawara or a fountain as claimed by the Muslim side, a simple investigation will tell you whether it's a fawara or not. Why are you shying away? Why is the Muslim side shying away from any kind of scientific investigation? Respond to that argument.
I think The Honorable Court is seized of the matter. And we should believe upon Honorable Courts that whatever decision will come, that will be just and proper. We have always believed about the wisdom of Honorable Courts, and we have always respected the orders of Honorable Courts. So today the order has been passed by a court. So please don't say that why we are shying away, why this and that. So my only contention is that let peace should prevail, let India should win. In all probabilities, India should not be divided.
No,
further.
I appreciate your spirit, sir. I appreciate your spirit, your constitutional, legal, and the spirit of being Indian. But let's come to the merit of the debate. There must be reasons why the Muslim side is saying that we don't want any kind of investigation, because I believe they are also rational people. What are the reasons? That's what I want to know, sir.
In fact, I am the last person to debate on the orders of the Honorable Courts. I never debate on orders of Honorable Court. The order has been passed. The order may be challenged by them. They have all rights to challenge that order. Either before Honorable High Court of Delhi, or they are saying that they will challenge it before Honorable Supreme Court of Delhi. So whatever orders would be passed finally by the Honorable Courts, that will be respected by all, whether the Muslim side or Hindu side. So in fact, this causes immense pains to me when we say Hindu side, Muslim side. We should say that we Indians, though we are fighting for something, they are fighting for something. So
well,
at
sir,
last,
I really hope
so
that there was no Hindu
divide.
side versus Muslim side. They are there in religious debates, and I'm going to call it what it is. That is what is the reality. Firoz Bakhsh is also with us on the broadcast. Firoz ji, how do you see today's order? More importantly, one of the key questions that Mr. Ratan Sharda also asked at the beginning of the debate, I'm going to take that to you, because Shahid ji did not answer that question. That is it correct to say that the Muslim side is shying away from some kind of investigation, or as Shahid ji said, that let's follow the due process of law. The courts are doing their job, and we'll know in few minutes or few days from now.
Listen, Anusha ji, I heard all my learned friends, and I would request them just to give me some quality time, including you as well. See, I am a very small fry, a citizen of India, but my take on Gyanvapi as well as on Ram Temple was that these issues should be amicably settled out of court in a spirit of amelioration. Right. Anyway, when the case goes to a court of law, then what happens? One side loses, one side wins, and there are feelings. There are feelings, of disparagement. There are feelings of enmity like this. So I was not. In fact, the masjid, the managing committee made a huge mistake when those 5 sisters, Hindu sisters, went, for this Gaurish Shringar Puja at that place. They should have allowed. And we people wouldn't have been debating this issue. They would have been, doing their puja, and namaz would have been going on as usual.
Here we are. We are. And, I'll let you complete, sir. But do you remember the number of times the court, the High Court and the Supreme Court tried for mediation in the Ram Janmabhoomi dispute? The number of attempts that the Supreme Court and the High Court made to make sure that the both sides sit together and come to a resolution? It did not happen. It's a utopian idea in this country. It does not work. Courts have to settle the matter, and the matters get settled in an adversarial matter, whether we like it or we don't like it.
Absolutely, Anusha. And I would appreciate, Shahid Ali when he said that let it not be a Hindu or a Muslim thing, it should be an Indian thing. And since the matter is in the court, I believe, and as Vishnu Jain, I heard him in another debate, he was saying that he would approach the Supreme Court for carbon dating scientific test. I think they should go for it so that the matter is decided once and for all.
Okay.
Because, this way debates will go on, the precious time of the government and of these channels will be wasted. So let there be carbon dating.
But I do believe, Firoz ji, that these are issues that should be discussed in the public discourse. They've been pending for a very long time. Ranjana ji, I also want you to come into the debate. How do you see today's order? सुप्रीम कोर्ट से क्या उम्मीदें आपकी, क्योंकि जैन साहब थोड़ी देर पहले बता रहे थे that they are going to go to the Supreme Court and seek a clarification.
First, I am saying that we are fighting for last so many years for our last glory. And order passed on application number 250 will not give any bad or adverse effect on the merit of the case, because the suit has already been filed for removal of the structure and allowing the darshan puja of Mata Shangar Gauri. So in this manner, the order which has been passed by district court today on the application will not affect the merit of the court in any manner. And as already stated by Mr. Jain, that we will challenge this order before the Honorable Supreme Court. And I want to point out one thing, that if anybody wants to determine the religious character of the Shivling which has been obtained during the commission report. So religious texts are the important scientific methods and historical books are very important for determination of all these things.
All right, Ranjana ji, we are having a problem in your audio. We'll just try and fix that. Before I go back to Mr. Ratan Sharda, Danish Qureshi, please come into the debate. There has to be a scientific investigation at some point in time to determine the nature of the structure that has been found within the Gyanvapi mosque complex. Today, the district court has denied that request on the grounds of procedure because there's a Supreme Court order in the wisdom of the district court that stands in the way. But at some point, this debate will have to be settled. There has to be an investigation to figure out what exactly is inside the complex. That's why the Supreme Court has given prohibitory orders. Danishji.
I think that carbon dating will not decide what is the structure. As per my knowledge about the carbon dating, it will only decide the age of that particle which is being dated by carbon. Second thing is that, as per my view, district court doesn't have to entertain this petition until and unless the Act of 1991 repeal. Because when a law has been enacted and which is the part of the basic structure of the Indian Constitution, remember one thing, Indian Constitution means the inclusiveness of all.
No, but 1991 Act is not part of the basic structure of Indian Constitution.
Ma'am, please go through the judgment of the Babri Masjid. What did the Supreme Court say?
I have read Kesav Nanda Bharti case, which is the basic structure case of this.
I can give you.
Please go ahead, make your argument. Please go ahead, make your argument.
Okay. Now, second thing is that until and unless the Places of Worship Act has been executed, nobody can entertain such petition. Remember one thing: what will be the decision? Let go down. If decision come in the favor of one community or another community, can you change the basic structure of the? Can you change the nature of the structure which has been known as the mosque? How you can?
The argument, Danishji, let me answer that. The argument of the Hindu side is that if it's a Shivling, then the character of the place was changed earlier and the original character is actually something else. Respond to that.
But ma'am, remember one thing, before 1947, we were living as an uncivilized manner. After 1947, in 1950, the Constitution of India has been executed in entire country, and from the deadline of the 1947 15th August, that's why we have enacted that law in 1991 that according to the Places of Worship Act, no religion place will be challenged in such manner.
The structure of the temple. The structure of the temple indicates that in the line of that, what Mr. Sharda and Mr. Vishnu Jain calls a Shivling, there is also a Nandi. So as the Mughal structures were there, they had their own signs. In the same way, the temples also had their own signs. In the line of Nandi, there is this, always there is a Shivling. So that has to be decided, and only a scientific method, that is 3 plus 2 is equal to 5, this can be decided by carbon date. Carbon date will decide the age.
Okay,
finally,
Danishji, make your argument. Danishji, make your argument, then I have to bring in other people as well.
Okay. Baksab, I am not agreed with this argument, because remember one thing, if for sake of argument, if any Mughal king has destroyed the mandir, can any ideals or deities, if they can left, can in Islam there is a space for Buddha Parasti? Oh, there is not.
I want to bring in Mr. Ratan Sharda into the discussion. Mr. Sharda, while you respond to many points that have been raised in this discussion, I don't think I've got a direct answer to the question that where is the need to shy away from any kind of scientific investigation if it's merely a fountain?
Well, actually, I am not surprised, because the same arguments are used for Ram Mandir also. There also they tried to delay everything. They refused every kind of scientific evidence, every kind of historical evidence. And when he says that suppose there was your Mughal attack, I mean, what is the supposition? Aurangzeb's diaries, his historians' diaries clearly state that this was destroyed, Gyanvapi was created. That's why the Shivling was not there. And that was renovated by Ahilya Holkar. Everybody knows a part of history. Entire Mughal history is full of idol breaking. So where is the surprise? My question is nature of worship bill was brought in to to calm down the evidence, calm down the atmosphere of 1991. But does it make it kind of some kind of holy book which cannot be touched, which cannot be relooked? Thirdly, Section 4 of the same Act says that the structures older than 100 years do not fall under this particular purview. It has been discussed multiple times. And, finally, if you go ahead, is peace only the initiative of Hindus, not Muslims? So all bhaichara, when they talk about, where does it bhaichara go when it comes to give and take? These Muslims are not invaders. Why do they want to defend something which is done by invaders, not by them?
Danishji, come in on this point. Danishji, come in on this point. That, Please respond to this point that the Muslim brothers of this country, as Ratan Sharda said, are not invaders. There was an interesting argument that Firozji also made some point ago that in an ideal world, we should have really sat down and solved these disputes. But the history of aggression is not recognized. The manner in which certain deities were disrespected is not recognized. And that is why these disputes today have to be settled in a court of law.
Ratan Sharda ji, as per I have read the judgment of Babri Masjid, the court kept the fate beyond the fact. Am I right? And according to the which law this judgment was, who has authored that judgment? Nobody knows. Pre-judge benches are signing the judgment, but who is the actual author? Nobody knows. So let me allow to complete. Now what? Now come to the point. If there was remember,
Ratanji, मैं आपको समय दूंगी. Let him finish. I'll come to you, Ratanji.
No. Why did the 5-acre land was been given to the Muslim parties? Why? Is that was the compensation of that land? And if that was compensation, then why that land was being snatched from the Muslim community? And I have saw the Babri Masjid. Will you allow to pray, offer me namaz over there because I have saw the masjid? And this is not demolished by any Mughal. This has been demolished by the terrorists of the country. Those who have leading
Mr. Ratan Sharda, please respond. Mr. Ratan Sharda, please respond.
See, these are twisted arguments because it was clearly established.
Danishji, I gave you time. Let him respond now. Fair debate.
Clearly stated that this decision is taken based on the carbon dating, on the radiological evidence and every kind of historical evidence. The history of this particular struggle, Ram Mandir, is noted it's more than 400 years old, and dispute in the court was more than 130-year-old. So let us not try to go back. You are questioning the very judgment. You are saying you don't know about the author of the judgment. This is a unanimous decision. So you are doubting a Supreme Court. You are doubting the judgment because you don't like it. That is the problem. It was only a resolution. Why are you shouting? I stopped.
दानिश जी उनकी बात पूरी करें. लेकिन दानिश जी argument ये भी है ना that you have to criticize a judgment on the merits of it, on the reasons of it. Merely because it has gone against you, you don't have a plausible reason to really criticize the judgment. You are merely saying किसी ने sign नहीं किया था. Unanimous judgment था वो.
I am an Indian citizen and I have a right. If you file a petition in the Supreme Court, you have to make a detail that who has drawn and who has drafted this petition, and the judgment, the historical judgment in the history of India was been given by the Honorable Supreme Court, and nobody knows who has written this judgment.
It was unanimous decision, my friend. It was unanimous decision. That's the fun, including a Muslim judge. So when there is unanimous
this is not about Muslim judge. No, so in the Supreme Court, nobody is Hindu and nobody is Muslim. Ratanji, don't try to compare apple and oranges. That is no Muslim. That is the judgment given by the judge, not by Hindu or Muslim.
सुप्रीम कोर्ट बेंच में दिए हुए मेरे भाई. सुप्रीम कोर्ट की जजेस
हिंदू और मुस्लिम का सवाल ही नहीं है. सुप्रीम कोर्ट का जज होता है, जो हिंदू और मुसलमान नहीं होता. आप उसको हिंदू और मुसलमान की व्याख्या में ना बांटें. मेरी आपसे रिक्वेस्ट है.
गंगा जमुना तहजीब dries up as soon as the law favors the Hindus. When Hindu wants something, गंगा जमनी तहजीब totally dries up.
जबानी जमाखर से नहीं, in terms of action होनी चाहिए दोनों तरफ से.
Okay, I am short of time. I want to give in 1 minute to Mr. Firoz Bakht Ahmed as well. Firozji, make your point.
I have a very simple point to make. You know, the judgment of Ram Temple which came, after that Muslims did not shed tears, Hindus did not thumb their chest, we have won and we have lost. There was a feeling of camaraderie and brotherhood. However, I think, you know, had this Ram Temple decision been settled outside the court, I mean, we would have got the same feeling
There
as
is
we
no
had in
Truth and
1857.
Reconciliation Committee in this country. There has never
Tatya
been
Tope and Bahadur Shah
harmonization
Zafar
of
leading
some
the
very
Indian
important disputes that
crowds
should have happened.
for
And
independence.
Mr. Ratan Sharda, last 30 seconds to you. Do you see this dispute once again lingering in the courts for decades like it happened in the Ram Janmabhoomi case?
That's what I'm afraid.
I regret this because the district court was going very fast. It was going decision, but somehow it has hesitated. Suddenly, it's got stalled in the final step because it had Supreme Court's blessing. It has Supreme Court's view in favor of the judge, but just somehow seems to have just stopped his work and did not go to 20th May of judgment of the Supreme Court. Maybe people like who are sitting on the panel, kind of the people who create pressure on the judges and probably thought, why take on myself, let us go to Supreme Court. Whatever it is, we don't question the judge. We say he did a certain thing. The appeal can go even to him because there is no need to, there are hundreds of procedures. He could have asked the ASI, called them and asked them what are the methodologies. But anyway, now since it has gone ahead, it is a 500 years of struggle for Hindus to, find some balm for their huge civilizational pain, which my Muslim brothers don't realize. That leaders who want to keep on creating hate, they don't realize. They could easily have realized and resolved the solution when it was talked of only 3 temples.
Okay.
But they
Sharda, let us end on this couplet. Let us end on this couplet from my friend Afzal Manglori. Mandir bhi le lo, masjid bhi le lo, insan ke lahu se magar ab na khelo.
Well, sir, we hope that the peace prevails, and that has been the entire focus of the Supreme Court as well. But I do think that these issues cannot be sentimentally handled. They have lingered on in this country for a very long time, and unfortunately, it's only through adversarial litigation where two sides fight it out in a court of law. These debates, cultural, political debates, are going to be settled. Mr. Ratan Sharda, Ranjana Agnihotri, Firoz Bakht Ahmed, Shahid Ali, and Danish Qureshi. Thank you, everyone, for joining us on this broadcast. This will go to the Supreme Court, as Mr. Jain pointed out. A clarification application is going to be put out, and then the top court will decide how to move forward in this entire dispute.